Your doctor claims he can't find your medical records. What happens if you want to bring a lawsuit against the doctor and now he claims he doesn't have your medical records? What can you do? You want to know the answer? Come join me for a moment as I share with you some remarkable information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. In a medical malpractice case where you believe a doctor violated the basic standards of medical care, causing you significant harm and injury, you know that one of the first things we have to do is obtain your medical records from your treating doctors. We need to evaluate those records and have a medical expert review those records to confirm not only that there was wrongdoing, but that the wrongdoing caused injury and that the injury is significant and permanent. But what happens if the doctor claims those records are lost, or they were destroyed, or they got destroyed in a flood, or the building burned down, now he no longer has those records? Can you still go forward with a lawsuit and show to a jury that you are more likely right than wrong? The answer is maybe. It's going to be extremely challenging, and here's why. We need a medical expert to review those records to determine what was done. We need to know exactly what the doctor did and didn't do. We need to know what complaints you made. We need to know what the doctor's treatment course was. So now, in order to evaluate whether or not the doctor did something improperly, our medical expert has to rely on what? The doctor's medical records. If he doesn't have those records, if they've been destroyed, guess what? What can the doctor use then? If there are no medical records available, then what can our medical expert rely on in order to form his conclusions that there were violations from the basic standards of medical care? Well, obviously you're going to have the patient telling you what was done, then you'll have the doctor trying to remember what was done, but then it becomes a he said, she said situation. And the reality is, in every one of these medical malpractice cases, we rely on the doctor's medical records in order to prove our case. The doctor is required by law to keep a patient's medical records for a certain number of years. If this is a natural disaster, what can you do? The problem is it's going to be extremely challenging to show ultimately to a jury that we are more likely right than wrong if we don't have the benefit of the doctor's records. The doctor's own malpractice insurance company may turn around, and if this is a pattern, may obviously think that this is intentional rather than an accident. And that could raise significant problems for the doctor. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what can happen if we are unable to obtain the doctor's medical records to evaluate whether or not he violated the basic standards of medical care. You know, I realize you're watching this because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, @oginski-law.com. That's it for today's quick video. I'm Jerry Oginski. Have a wonderful day.